She laughed the second I said I would stand alone. It was not surprise or nerves. It was certainty. Her eyes moved to her lawyer, his smile answered, and a quiet wave of amusement spread across the courtroom. To them I looked outdated, stubborn, unprepared. A man past his prime, refusing help. No famous firm behind me, no tailored arrogance, only a thin folder and still shoulders. In their minds, the hearing had already ended before it began quietly inside. I remained silent as names were called and files arranged. I felt the rhythm of the room settle into routine. Judges notice rhythm. Lawyers rely on it. I studied her posture, the way confidence made her careless, the way comfort dulled attention. I had waited months for this hour, learning rules, reading cases, memorizing my own life. I was not there to impress anyone. I was there to let time obey me without rushing a single fragile moment today alone. When the judge asked if I understood the danger of representing myself, the room leaned forward. I answered calmly, explaining I accepted responsibility for every word I spoke. No speeches, no excuses. Her smile sharpened, convinced humility meant weakness. She expected hesitation, maybe fear. Instead, she met patience. The kind built through long nights and private losses. I was not gambling. I was executing a plan shaped by restraint earned slowly over years nobody ever noticed until that very day. She kept smiling as proceedings moved on, still certain the story favored her. I allowed that comfort to grow. People reveal themselves when they feel safe. I asked nothing yet. I listened to each claim, each assumption, each polished line. The court was quiet now, focused, attentive. Laughter had disappeared. Confidence filled the space where caution should have lived. I recognized the moment because I had lived it once before and paid dearly with trust misplaced and lessons learned hard. I never looked at her as she waited for me to fail. I watched the judge instead, steady and unreadable. This was not theater. It was alignment. Facts, timing, and silence moving together. She believed I arrived empty-handed. She believed my calm meant surrender. She was wrong on both counts. I had not come to fight loudly or beg quietly. I came to let the truth stand on its own and begin its work without mercy or noise today. People thought I stood alone because I was reckless or too proud to ask for help. That assumption worked in her favor. It made me look smaller than I was. The truth was quieter and far less dramatic. I had sat in offices across polished desks and listened to experienced attorneys explain the safest path. They spoke of compromise, discretion, and moving on quickly. They were not wrong. They were simply speaking to someone who wanted peace. I was speaking to something deeper than peace. I wanted accuracy preserved in daylight. Nothing mattered more at this stage of my life. I knew the details of our shared history better than any file ever could. Dates, transfers, emails, signatures, pauses, and silences lived clearly in my memory. A lawyer would compress that into argument. I needed it untouched. I needed the court to hear facts without polish or protection. Representing myself removed filters and theater. It left only precision. That frightened her side because there was no interpreter to soften impact or redirect attention. Every question would come directly from the source, steady and unavoidable. I trusted preparation more than persuasion at this point in my life and future integrity itself. She misread my choice as emotional resistance. That misjudgment comforted her. While she shared plans and confidence with friends, I built structure in silence. I studied procedure late at night, rewrote timelines, and challenged my own memory until only facts survived. There was no anger driving me, only discipline. Preparation does not announce itself. It accumulates quietly until it becomes immovable. By the time court arrived, I was not hoping to win. I was ready to present reality without decoration or apology. Age teaches patience, restraint, and respect for consequences earned through experience rather than impulse and long reflection alone. Standing alone was not rejection of help, but selection of responsibility. I wanted every sentence to belong to me. No distortion, no delay, no performance. I understood the weight of that choice fully. If I failed, the failure would be honest. If I succeeded, it would be undeniable. She never saw that difference. She believed confidence wins cases. She forgot courts reward coherence. When preparation meets timing, truth does not need defense. It simply waits, then steps forward when invited. That understanding changed everything before the first word spoken in that courtroom, and beyond it forever for all involved present. Her lawyer began with confidence, voice polished and timing precise, delivering a narrative designed to sound inevitable. He spoke as if the outcome were already written, glancing at her for reassurance. She smiled easily, enjoying the performance, convinced this was formality before reward. I listened without reaction, hands still, eyes attentive. I noted what he emphasized and what he avoided. Experience teaches that openings reveal priorities and fears. I did not interrupt. I let the structure build. The room settled into his rhythm, unaware that rhythm can be broken not by force, but by questions asked at the right moment. When my turn arrived, I stood without urgency. I did not counter his claims or raise my voice. I began asking questions, simple and factual, about dates, amounts, and signatures. The answers came quickly at first, too quickly. She responded before thinking, then paused, then corrected herself. A glance toward her lawyer followed, brief but visible. The courtroom noticed a shift. The judge leaned forward slightly, pen suspended. Confidence remained on her face, yet ease was gone. Precision had replaced performance, and precision leaves little room to recover once momentum changes. Silence grew heavier as certainty quietly began slipping away. I remained measured, asking nothing dramatic, letting each small inconsistency stand alone. Courts do not need accusations when patterns emerge naturally. She adjusted posture, crossed her arms, uncrossed them, smiled again briefly, then stopped. Her lawyer attempted to redirect, but answers already existed on record. I could feel the room recalibrating, attention narrowing, noise dissolving. This was the first moment she understood something was different. I was not searching for arguments. I was mapping facts publicly. Improvisation fades when structure is revealed, and structure had quietly taken control of the hearing. That realization arrived slowly, unmistakably, and far too late. Her smile never vanished completely, but it no longer led the room. It followed events instead of shaping them. For someone accustomed to control, that shift is unsettling. I sensed it immediately. She realized I was not experimenting or hoping for sympathy. I had rehearsed restraint, not speeches. Each question narrowed options. Each answer removed space. The judge watched closely now, no longer passive. This was not conflict. It was exposure. The crack in her confidence was small, but once formed, it widened with every second she remained on the stand. From that point forward, the balance shifted beyond recovery. I learned long ago that silence unsettles people more than resistance. I did not interrupt or object theatrically. I let statements sit untouched, allowing their weight to reveal gaps naturally. Each contradiction remained visible, unchallenged, suspended in air. Her lawyer attempted to recover tempo, adjusting tone and posture, but rhythm, once broken, rarely returns. With every response she gave, another thread loosened. I stayed still, observing, recording mentally, letting momentum work for me. Silence was not absence. It was pressure applied evenly, patiently, until structure began to strain under its own assumptions without spectacle or wasted emotion during proceedings there. Her attorney sensed the shift and spoke faster, hoping speed would restore control. It did not. Answers piled up unevenly, some precise, others rushed. The judge leaned forward, eyes narrowing slightly, no longer observing casually. He began addressing questions directly to me, seeking confirmation and clarification. I answered briefly, respectfully, never elaborating unless asked. Authority gravitates toward clarity, not volume. The courtroom adjusted its focus instinctively. Pens moved, pages turned, breathing slowed. The earlier amusement evaporated, replaced by attention sharpened through quiet tension that demanded accuracy from everyone present, including her lawyer, and witnesses alike without exception today there. I noticed when she stopped smiling because absence reveals more than expression. Her posture stiffened, confidence replaced by calculation. She watched the judge instead of the room, measuring reactions she once controlled. The comfort she carried into court dissolved quietly. I continued, saying less, trusting sequence over persuasion. Facts aligned themselves when undisturbed. Her lawyer paused more often now, checking notes unnecessarily. The silence between answers grew longer. In those spaces, realization formed. This was no longer a performance to win approval. It was an examination, and examinations favor preparation over charm, especially in courtrooms like this on record today. She avoided my eyes entirely now. The earlier laughter felt distant, almost embarrassing in hindsight. I felt no satisfaction, only steadiness. This moment confirmed why restraint mattered. Silence had shifted authority without confrontation. The room followed substance, not spectacle. I understood then that momentum had changed permanently. From this point forward, every word would be weighed carefully, every claim examined openly. She sensed it too. Her certainty had fractured. She was no longer certain of outcome, only aware that control had slipped away quietly, methodically, and beyond her ability to retrieve within that courtroom space during the hearing itself there. The shift arrived quietly, without raised voices or surprise gestures. When the moment came, I stood and handed the clerk a document already logged and indexed. No announcement followed. No explanation yet. It was a financial record she had never mentioned because she never imagined mattered. The date connected directly to a sworn statement she had delivered weeks earlier with confidence. Same account, same period, different conclusion. I watched her eyes narrow as recognition lagged behind assumption. This was not exposure by ambush. It was consequence arriving on schedule, indifferent to emotion that she could no longer dismiss it. Her lawyer reacted before she did, standing to request a recess, voice controlled but urgent. He framed it as procedural necessity, citing fairness and review. The judge did not raise his voice. He simply declined, stating the record was admissible and relevant. That refusal altered the air instantly. Paper stopped moving. No one whispered. I remained seated, hands folded, letting process do the work. This was not about catching anyone unprepared. It was about alignment between testimony and reality, now visible to everyone present in that room, including her for the first time since proceedings began that morning in court. She finally looked at the document, really looked, lips pressed together as memory collided with ink. Her confidence did not shatter loudly. It retreated inward. The lawyer beside her leaned closer, whispering too late. The judge reviewed the page carefully, then compared it to earlier testimony without comment. Silence stretched again, heavier than before. I felt no triumph, only confirmation. Preparation had created inevitability. This paper did not accuse. It clarified. Once clarity enters a room, denial becomes exhausting and fragile under sustained attention. She understood that immediately and feared the implications deeply despite remaining outwardly composed for now there. That moment marked a turning point, though nothing dramatic occurred. No ruling was announced. No voices rose. Yet something essential shifted. She realized the ground beneath her narrative was unstable. I realized restraint had carried me exactly where needed. The court moved forward methodically, but the balance was gone. This was not victory. It was awareness settling in. Awareness cannot be argued away or negotiated. It stays. From then on, every answer carried weight she could no longer manage with confidence alone. The room sensed it clearly, even those previously amused by her early laughter at the beginning of court. From that moment, the courtroom stopped evaluating my choice to stand alone. Attention shifted towards substance, not strategy. Every statement was measured against records, timelines, and consistency. I answered when asked, briefly and directly, without persuasion. The judge began organizing the hearing around facts rather than argument. Pages were marked, numbers circled, dates aligned. The audience sensed the change immediately. This was no longer about legal theatrics or confidence displays. It became an examination of reality itself, unfolding step by step, immune to charm. I felt the current turn and let it carry the proceedings forward steadily. Her posture altered without announcement. Shoulders tightened, voice lowered, confidence recalibrated into caution. She stopped addressing the room and focused on the bench. Her lawyer no longer smiled or interrupted. He listened, adjusted, wrote notes, and hesitated before speaking. These changes spoke louder than objections. Experience teaches that authority follows coherence, not volume. The judge began taking deliberate notes, not routine marks, but observations meant to endure. Each line written confirmed that accountability had replaced assumption, and momentum had shifted beyond anyone's control. I remained aware that this reversal was irreversible. Once a court commits to facts, narratives lose power. I watched her avoid my direction entirely, eyes fixed elsewhere, measuring consequences instead of projecting dominance. Silence now worked against her, not for her. Answers slowed. Clarifications multiplied. The pace belonged to process, not personality. I offered nothing extra, trusting restraint. For an audience seasoned by life, this is recognizable truth. Control fades not through confrontation, but through exposure sustained long enough to remove illusion and leave only record. She understood then that the hearing had outgrown her confidence. This was no longer a contest she could manage with presentation or certainty. The structure had closed around her story quietly. I felt neither satisfaction nor relief, only focus. The shift could not be reversed because it belonged to method, not emotion. From that moment forward, every response carried consequence. The court was no longer watching a man represent himself. They were watching facts take control, and nothing unsettles false certainty more than truth advancing without resistance. For her, realization arrived slowly, heavy and unavoidable, as experience teaches adults that power rarely collapses loudly, but slips away quietly when evidence accumulates, leaving no space to negotiate, reinterpret, or escape responsibility once the record is complete and consequences finally become unavoidable for everyone involved there. When the judge began reading the decision, the room did not tense or erupt. It settled. Papers rested. Chairs stopped shifting. I felt no rush of victory, only attention sharpened by consequence. His voice was even, deliberate, uninterested in emotion. He spoke of responsibility first, then credibility, then intent. Each word landed cleanly, without commentary. These were not phrases for headlines or reactions. They were terms that live inside records, reviewed years later without memory of laughter or confidence. The courtroom listened because outcomes were now fixed, independent of belief. No one interrupted, questioned, or reacted as finality settled completely. She remained still as the meaning reached her slowly. The certainty she carried for months collapsed inward, leaving calculation behind. She did not object or whisper. Her lawyer said nothing. Guaranteed outcomes vanish quietly when precision replaces persuasion. The judge referenced inconsistencies without accusation, aligning testimony with evidence already admitted. I noticed her hands tighten briefly before relaxing again. This was not humiliation. It was correction. What she lost was not a case alone, but the illusion that confidence could substitute truth when examined under steady light. That realization arrived without drama and stayed, heavy, permanent, undeniable, in her silence. I listened without reaction as the ruling concluded. There was no desire to look toward her. I focused forward, understanding what this moment represented. Precision had carried weight where emotion failed. I had not needed to raise my voice or accuse. Facts performed their own work once allowed space. For anyone who has lived long enough to see reputations shift, this outcome felt familiar. Control fades when accountability enters. The record now spoke clearly, and it would speak long after everyone left the room. Time would confirm that silence often delivers the loudest verdicts without argument or spectacle ever recorded. Her earlier laughter existed only as memory, stripped of power. No one acknowledged it aloud, yet everyone remembered. I gathered my papers calmly, aware the process was complete. This was not triumph. It was closure earned through restraint. She remained seated longer than necessary, absorbing consequence without language. The court moved on to schedules and procedure, indifferent to emotion. That indifference marked the true ending. For adults, this is justice. Not noise, not revenge, but accuracy standing firm when belief finally collapses. Nothing needed emphasis, because truth had already finished speaking for itself within the record permanently sealed that day. After the hearing ended, people approached quietly, offering congratulations without celebration. Their tone matched mine. Some were curious, asking why I never hired a lawyer once the pressure increased. I answered honestly and briefly. I did not need representation. I needed ownership. Every decision, every word, every pause belonged to me. There was no intermediary to soften consequence or absorb responsibility. At this stage of life, that mattered more than comfort, image,